So welcome everyone to the 16th annual ICDR YNI Coffee House debate, this time virtually because unfortunately we cannot meet in Vienna, but hopefully next year. But we wanted to keep the tradition alive and organize this webinar in our traditional date for the YNI Coffee House debate. I will take just a moment of your time to remind you of ICDR Young and International and Rafael Carmona, and I am very involved with our Young Practitioners group, to which you can join if you visit our website. If you Google ICDR Young and International or YNI, you will find us, and there's a registration form in Spanish and in English. You can choose, and then you can join as a YNI associate. You will also find there our previous webinars that are recorded and uploaded there and to our YouTube channel. And also you can join our LinkedIn group. If you look for ICDR Young and International, you can request to be joined to the group and we'll accept you. We're going to be posting all of our updates there and some other initiatives that we think you might find interesting. With that, I don't want to take any more of your time, and I want to briefly introduce our speakers that are going to be debating today. First of all, Kristina Fridman, she's an associate at Baker McKenzie in New York. We also have Yehia Shahine, a partner at ALC, Alilden, Wishahi and Partners in Cairo. We have Juan Pablo Moyano, associate at Holland and Knight in Mexico City and former ICDR director in Miami. We have Marcus Irajinia Berglie, senior associate at Mannheimer Swartling in Gothenburg, although he used to travel a lot to Stockholm, as I understand, before everything happened, hopefully also in the future. We also have Sherlin Tung in Hong Kong, a partner at the Withers Worldwide. We have Gretta Walters, counsel at Chaffetz Lindsay in New York. And we have, of course, our moderators that are very interested in giving these panelists a hard time today. Mark Kantor, an independent arbitrator in Washington, D.C., and Patricia Shaughnessy, professor at Stockholm University, obviously in Stockholm. So with that, Patricia, I think the floor is yours. Thank you.
Thank you very much, Rafa, and thank you to all the participants who are tuning in the morning, afternoon, or evening, wherever they may be on Sunday. Let's get started right away. We're going to launch the first debate, and this is going to be a very robust debate. Things are going to move quickly. And the first debate topic is that the joinder of non-signatories should be decided under the law of the place of arbitration. And that the colors that they're wearing will help you to identify which side they're on. And your moderators do not have backgrounds, but we're yellow because we're directing traffic. And that's how you can identify us. With that, may I invite the proposition proponents to please make their short opening statement.
All right, perfect. Thank you so much. I will be doing the opening statement for this first proposition. Hello, everyone. My name is Juan Pablo Moyano from Mexico City. So as to this first proposition, of course, the joinder of non-signatories should only be decided under the law of the place of arbitration. Of course, there are sufficient compelling reasons to reach this conclusion, and today I'm going to present you with some very specific arguments for this. So first and foremost, joinder is a procedural issue, and it is the law of the seat that provides the rules on which types of internal procedural issues the parties may agree on. This also applies to other procedural aspects of an arbitration, such as the arbitrator's power of discovery or the power to issue provisional remedies, for example. Therefore, logic dictates that the law of the seat should also apply to issues of joinder of non-signatories. Since it is a procedural matter, the law of the seat determines the extent of the power of the arbitrator. Second, in case of a conflict, say, between a very narrow joinder provision in the law of the seat and a broad joinder provision in arbitration agreements, the conflict should be resolved by the law of the seat. as the presumptive law of the agreement. Subjecting mandatory procedural principles to different laws, such as the law of the seat and the law of another party, would give rise to enormous uncertainty and conflict. Third, issues of joinder of non-signatories may turn on issues of validity of consent. And in many cases, this will have to be decided based on domestic contract law principles that would therefore be also governed by the law of the seat, once again, as a presumptive law of the agreement. And finally, while it is true that in most jurisdictions, the power to order joinder will first be left for the tribunal, these decisions will be subject to subsequent judicial review. And the law that the courts of the seat will have to consider in order to decide these actions will be the law of the seat. Now, an order to join a non-signatory that is contrary to the law of the seat would very much risk going against, for example, New York Convention Article 5, specifically 1D, because the award would not be in accordance with the law of the seat. It could also be contrary to Article 5.1a, because the agreement could be contrary to the law applicable, which will be the law of the seat in nearly every case. Thus, it makes sense for joinder to follow principles of the law of the seat when considering joinder of non-signatories. For my part, I conclude that deciding on joinder of non-signatories based on the law of the seat is the only real viable method. Thank you so much.
And may I invite the opening statement?
Thank you, Patricia. This is Yehia Shahine, head of arbitration at Irajinia, and I'm based in Cairo, Egypt. Before even I plead my case, the proposition from the other party, we have heard a lot of could. So this would leave anyone with an impression that it could and could not. So my position is the joinder of non-signatories should be decided based on many laws, depending on the case and the circumstances of the case. And the law of the place is only one of them. And this goes with the could that has been used by the other party when pleading their case. First, and before I jump into the conclusion about, or the discussion about the place and the seat and the place and the usage of the law to govern this issue, I would like just to draw a distinction that may not have any legal significance in many jurisdictions, but drawing on my experience in Egypt, we had a very heated discussion a couple of years ago regarding the distinction between the seat and the place. So if we follow that distinction, we'll find that the seat has a legal significance because the seat, based on the seat, it will be decided the juge d'appui, it will be decided the judge for annulment, and the place is only the place where part of the proceeding may take place. So if we follow this distinction, the place of arbitration will bear absolutely no significance, and the law of the place would also bear no significance. But let's assume arguendo that the seat is the place in order just to follow the discussion. And here, the emphasis should be made on the nature of the arbitration itself. Arbitration is consensus by nature, and the nature of the arbitration is based on this consensus and on the arbitration agreement itself. So the law governing the arbitration agreement itself plays a major role in the arbitration proceedings. It defines the scope of the jurisdiction of the arbitrary tribunal, the limits thereof, validity thereof, and limits, it means the limits passione persona and ragione materiale. So when defining its jurisdiction with respect to the persons included in this scope, the tribunal would certainly refer to the law chosen by the parties to govern the arbitration agreement. This law, it might be decided by the parties. And this case, this law should be applied in order to decide matters related to the validity and, of course, to the jurisdiction of the tribunal. Assuming this law has not been defined, or that there is a difference between the law of the seat and the law governing the arbitration agreement itself. And here, the tribunal, in deciding the facts and the circumstances of the case at hand, in order to decide whether there is a legal ground that can be used in order to include a non-signatory, someone who didn't consent to an arbitration agreement, into arbitration proceedings, it may refer to extra, I would say, and I use the word, it may refer to mechanisms and theories that are extra contractual, that are not really related to the law applicable to the arbitration proceedings itself. So in that case, the tribunal, and by deciding over the matter, would find that the law of the seat may bear some significance. So the law of the seat may have significance in cases where the parties to the joinder based their joinder based on elements of national law, and this national law is the law of the seat. And just to give an example, the agency, the assignment, these theories or these legal grounds, by using them, and only in these circumstances, the law of the seat may have or should be applied. But otherwise, if the tribunal refer or the parties request the application of a group of company theory or other theories that have been developed by the international practice of arbitration, in that case, the tribunal could definitely not be obliged to apply the law of the seat. Just to sum up and to avoid passing the time allocated to me, I will just conclude that the proposition that the joinder of non-signatories should only be decided under the law of the place of arbitration is not correct. The law of the place is one of the laws that may or may not be applicable by the arbitral tribunal. Thank you.
Yehia, thank you very much for that presentation, which went well beyond the time you were allotted. I wonder if we could ask Rafa now to take a poll of the audience. Our objective here is to determine whether you agree with the pro side or the con side, remembering that the question here is the joinder of non-signatories should only be decided under the law of the place of arbitration. We will take this poll now, and once the first debate has concluded, we'll take the poll again and see if either the tealers or the pinkers have moved the chains. So go ahead, all of you attendees, tell us what you think. It's looking pretty tight. We got a horse race going here. Of course, we got a lot of attendees who are refusing to vote. Come on, attendees. We don't know who you are. You can't be embarrassed. Getting a little better here. We got 29 votes out of 39 attendees so far. We may have to ask the panelists to vote to try to improve this. Oh, the in favor is moving. Oh, no, I was going to say the in favor is moving a lot ahead, but now the against is climbing back up. All right, let's give it 60 more seconds and then call the poll ended. Counting down by my watch, which has never worked correctly in its entire mechanical life. Look kind of stalled, but it's still very close. So far, it's 18 in favor and 16 against. That seems rather tight. And while we're waiting for my clock to spin all the way around, tealers and pinksters, get ready for the real debate, not this little pro forma scripted stuff you did already. Okay, we've just about used up a minute extra according to my watch. There are 16 against the proposition and 18 in favor of the proposition. That's a 6% size vote, and in US elections, that would be a landslide, but not here in international arbitration. So let's share the poll results with everyone and close out the poll and get directly to the debate. So the pro team, which says that the place of arbitration is the one and only place that we look to decide joinder of third parties. Of course, the US Supreme Court said you're absolutely wrong. They said you have to use a choice of law analysis. Why do you think you're smarter than the US Supreme Court? Come on, pro team, help me out here.
Well, I'm happy to jump in with this immediately. And the answer for me is really clear. And I think Yehia gave us the answer himself. I mean, the first words out of his mouth is that, and I wrote this down, the law applicable to joinder could be, quote, many laws. Jesus, what a nightmare. I mean, can you imagine having to decide these joinder issues from a many laws perspective? I mean, what if you have one party in country A, a second party in country B, a third party in country C, a fourth party in country D? Are you supposed to consider this question under each of their laws?
Well, Gretta, hang on just 1 second, Ms. Walters. You saying you're smarter than a unanimous Supreme Court? That was a unanimous decision. Really? Come on. Are you that egotistical?
Well,
yes, no, or I decline to answer on the grounds that I will self-incriminate myself.
Avoid answering that question, but I will answer your question about the Supreme Court. Mark, I know you are also very aware of the GE Capital case from the last term of the Supreme Court. Now that involved non-signatories, but the court there had no problem applying domestic contract law to decide issues that are related like this. And that's really what we're arguing at the end of the day, that domestic contract law principles are well suited to deal with this. And instead of having this multifaceted, multi-law approach looking to jurisdictions all over the world, there's one option that just makes sense for a matter of efficiency, uniformity, and that's the law of the seat.
All right.
Oh my goodness, Greta. What about all those cases where the parties have not decided the law of the seat? And it is decided later by an institution, by arbitrators. What happens to the contractual expectations of the parties on who is going to be able to be joined to the arbitration? I think that maybe Sherlin ought to defend you.
Well, I know she agrees with me, so I have no problem passing the mic over there.
Well, I mean, in a situation where the institutions, let me start off first. I am absolutely 100% supportive of Greta. But in a situation where the institution has to decide the place of arbitration, they also take the factors of the matter before the parties. They look at the parties' intentions. They look at everything leading up to where this agreement came from, how this arbitration ended up being commenced. And again, in my opinion, it goes back to what Juan says. It ultimately goes back to the consent. It's arbitration is a consensual private dispute resolution mechanism. Institutions will choose the law of the place of arbitration or the seat of arbitration.
Oh, Sherlin, I think you're showing that you used to work for the ICC for a long time. You seem to overestimate the ability of an institute to be able to determine what the parties anticipated at the conclusion of the contract as to who they might be in an arbitration with.
Absolutely not, because the institutions will always ask for comments and submissions from the parties before they make that decision. And the parties on these submissions will submit what they believe that they had intended when they entered into the contract.
So I see that the Teal team has said nothing. Does that mean you've just conceded? Are we about to go directly to coffee and biscuits? Don't you have anything to say? Kristina, I see you laughing. Is that the most you're going to contribute here?
I think that's a little unfair. I mean, for me, I think the issue is enforcement, right? That's what we're all concerned about at the end of the day, in terms of an arbitration award. And I think that if you don't look into various laws and apply general principles, you might get yourself in trouble when you're then trying to enforce the award. So I think that that's something that should be taken into
Kristina, is it really just a question of enforcement? Look at all these Moody's arguing this week about whether joinder should be allowed or not. I mean, once a joinder is allowed, it has a huge impact on how long the arbitration is going to be, how many parties are going to be in there, how many submissions are going to be in there, how much evidence, confidentiality, enormous things are going to be changed. And what about the party who said, I never agreed to allow Kristina's client into my arbitration?
I mean, yes, I agree that joinder is a big issue, and I agree that it's going to have a long-term impact on the arbitration, which again is why that only further counsels to the fact that you should look at several different laws and apply general principles, and not just to the place of arbitration or the seat of arbitration. So I would think that that only further supports our point.
I think
Mark?
Juan looks convinced.
You want to get this right? You want to get this right at the outset, because that's going to have a long-term impact on your arbitration. So I think you shouldn't take a narrow view to the issue.
Marcus, I think that Kristina needs a little help here. So are you going to come in and support your teammate? Or are you going to let her flounder the way she has been?
I'm happy to support Mark. I don't think she needs any support because she's doing brilliantly, but I'm happy to support her and offer my views. I think the discussion is framed incorrectly at the moment. The proposition is that it's the place of arbitration.
Attack the moderators, attack the moderators.
No, I'm not attacking the moderators, but I'm attacking the proposition team, arguing that the alternative to sticking to only the law of the place of arbitration would be application of many laws. That's not necessarily the outcome of a choice of law analysis that the U.S. Supreme Court has advanced. Essentially, since we're discussing joinder, consent is important. There are theories on joinder that are contractual consent based, and there are those that are non-contractual theories vested more in international law. And I think just having this one-eyed approach where you would look only to the place of the arbitration and exclude international law principles that have been developed to be tailor-made for international arbitration doesn't do us any favors. So I think we need to recognize that it's not the alternative to have many laws. I still think we need to make a choice of law on the law applicable to the arbitration agreement, which will then steer or guide arguments that someone should be joined based on a contractual consent theory. And adding to that, you could have these international principles that are recognized universally. For instance,
wait, it sounds like you're creating a lot of billable hours with all the different things that you want to consider to get to the cheese.
And I'm happy to do so. I think that idea is supported by all the lawyers in this debate.
Juan, do you agree with that? The more complex way to make a decision, the better.
Well, it sounds to me like the last part of that. It sounds to me like the other party was supporting a national arbitrations, and that is another very heated debate in many ways. No, I don't really agree with that. I still support the idea that it should be the law of the seat. The law of the seat at the end of the day is the presumptive law of the arbitration agreement. The validity of the arbitration agreement and issues of consent should be decided based on the law of the agreement, and that will be presumptively, and looking at New York Convention, because parties usually don't agree on this, will have to be the law of the seat. So yeah, I think our proposition is still correct.
Wait. Did you start with a false premise there? Did you say that the international default position is that the law of the seat is going to? Oh, I think we're going to get some pushback.
Yeah, I think it's clear. The last part in his sentence says it's all. He started with a strong proposition in order to end saying, if not agreed on the law to govern the arbitration agreement. So this is the key question. Do we have an agreement on the law governing the arbitration agreement itself? And if not, do we jump automatically to the law of the lex, to the seat, the lex arbitrie, or do we use other alternatives? So by taking just his words, you can conclude easily that the law of the seat is one of the laws. One of the laws does not mean that there is uncertainty or the legitimate expectations of the parties will be actually at jeopardy or something. It means that given the circumstances of the case, the result may be different.
I think that's absolutely right, but that doesn't mean that Juan was wrong in what he asserted, right? We have to look at the circumstances of the case. And here, there is no situation where we've expressly stated that there's a particular law governing the arbitration agreement versus the place of arbitration. What we've said and what we stand by is the fact that the issue of joinder, which is a procedural issue, needs to be governed by the seat of arbitration, because the seat of arbitration, or the lex arbitri, governs procedural aspects of an arbitration proceeding.
Wait. So are you saying, Sherlin, that when it comes to the issue of whether there's jurisdiction, that we should apply the law applicable to the arbitration agreement? And when it comes to the exercise of the procedural mechanism of joinder, we should apply the seat? Is that what you're suggesting?
It would depend on the situation, but I think for the specific topic of joinder, we should apply the law of the seat of arbitration.
Just to be clear, you're arguing, Sherlin, that we should apply the law of the place that has the best hotels and the best restaurants. After all, back when I was a deal lawyer, that's how we chose what the seat would be. We didn't know anything about this conflict of law stuff. We didn't know anything about arbitration. We were just dumb deal lawyers. Proud of it, too.
Mark, how long ago was that? We've come a long way in international arbitration. I feel like we've educated our colleagues and clients.
But not me, obviously, no matter how long it's been. No, so wrong. Oh, come on now.
I think we've seen enough bad. I think we've seen enough bad arbitration agreements to agree that it hasn't come that far. I mean, we can all agree that it's a provision that's added at the last minute at the end of the contract, and sometimes people are not paying enough attention to it. So I don't think that's fair.
Oh, now, wait a minute, Kristina, you go too far in impugning deal lawyers. I can assure you, in the kind of transactions I did, the question of forum and seat for an arbitration was right in the term sheet, not even in the definitive documents. It was a deal issue. My clients would not agree unless it was arbitration and unless it was a seat that was pro-arbitration, friendly to arbitration. The idea that it's the last thing that's agreed impugns my colleagues in the deal world. How can you say that about us?
Because it's realistic. I mean, it's not always the case, but it's too often the case. I think we have enough experience to say that that's probably true. I'm not
quoting the Bible,
but I'm just trying to push back a little bit on Sherlin's proposition that this is, we've come so far and this is something that's thought about. I think a lot of parties are not thinking about that when they're making their arbitration agreements. And so
let's focus exactly on what they're thinking about. Isn't consent the cornerstone of arbitration? Show me consent and who cares about conflict of law? Isn't that the right way to deal with this? Just look to consent. A simple, basic rule.
See, Mark, Gretta is smarter than the justices on the U.S. Supreme Court. Isn't that what you said, Gretta? Are you convinced, Mark, now?
Exactly, I think so. So we can add another one to our poll at the end of the day. I think so. And that's exactly where Team Pink, when Juan started his position, started. This is about looking at the party's consent. And that's why going to the seat gives you the best option for consent. I've written down why the other team was speaking, and we have a couple of options of them now as suggestions of other applicable laws beyond the seat. Yehia offered us the law applicable to the contract. Marcus proposed to us the law applicable to the arbitration agreement. But I mean, practically, what does that mean? First off, when you're dealing with joinder issues, it's not really a pure non-signatory issue, right? So you may have two contracts. For example, in the BIS problem this year, we have two contracts that are governed by different applicable laws. So how is that going to help us? And how does that show us anything about consent? In terms of the law applicable to the arbitration agreement, we're all talking about good, bad arbitration agreements. How often are we seeing arbitration agreements that have a consent to a law applicable to the arbitration agreement? I mean, just these other suggestions, they're not practical. They're not helping us get anywhere different. Yes, sometimes the arbitration agreements do not select a law or a seat, but many times, and the vast majority of times, they do. And that is a sign of party consent to that specific term. So let's give it effect.
But I think the key issue is you're saying in all cases, right? And you just said they don't always say what the seat is. And at that point, I think that the best way to get to party consent is to do a conflicts of law analysis. So I don't think you're getting to all, by saying that, because when it's not designated, then you need to do a further analysis in order to understand what is party consent.
But I think you're selling the parties' agreement too short. What about, even in those cases, let's say it's an ICDR arbitration where the parties haven't selected a seat. They've still selected rules and agreed to a procedure to select the seat, and there's a means to do so. So I mean, let's not sell the parties' agreement too short as to what's just on paper necessarily.
Kristina, what about the modern approach is that arbitrators do not have to go through a conflict analysis in order to arrive at what law they should apply, that they can directly go to what they think the law is applying. So is your team suggesting we move back in time and this complex conflict of law analysis is going to add a fight before the fight over the rules of the fight?
Well, I think the arbitrators, when they're just applying a certain law, they've done an analysis to determine what the law is that they're going to apply, right? That's implicit in their decision to apply a certain law. So we're not asking for anything extra. You know, I think that they're already doing that when they choose to apply a certain law. They've already engaged in that analysis and determined the law that's applicable. That's all that we're saying.
Mark, how many extra submissions do you think it would be in the beginning of an arbitration if we take the TL team's approach?
Well, obviously you have to have first a motion, then you have to have a response, then you have to have a reply, then you have to have a surreply, then you have questions by the arbitrators, which triggers the whole thing all over again. Now that doesn't work in an ICC arbitration because I'm stuck with the range that the ICC provides for my compensation. But it works great in an ICDR arbitration because I get to charge on an hourly basis. So thank you.
You're welcome. But I really think that at the end of the day, we're overselling, you know, we're over kind of selling the point, right? We're not saying that you can't go to the you can't go to the seat of arbitration in any circumstances. We're just saying all is not the right approach, and I think that's the bottom line. So yeah, sometimes the seat of arbitration is the best. I'm not going to argue that it's not ever, you know, but I think that there are certainly circumstances where the seat of arbitration just by default is not the way to go, and I think particularly where it's not specified is one of the prime examples of that.
Let me take this commercial before we have Marcus add on, that all of our participants are welcome to pose questions or to make their own argument in the chat, and then we will bring it in.
Patricia, may I proceed?
Yeah.
Yeah, okay, thank you. Yeah, I was about to fill in on what Kristina said, that the argument we're making is that the proposition, it doesn't offer a universal solution. The issue of non-signatories being joined is essentially, it's a question about the scope of the arbitration agreement. Can it be extended to those that didn't, you know, basically sign off on the arbitration agreement? And we all know that the parties can choose the law applicable to the arbitration agreement, and that law doesn't have to be the place or seat of arbitration. That's the default rule that kicks in if they haven't made a choice. If they made a choice and the law is different than the seat of arbitration law, then the proposition is wrong, and that does happen in reality. So the proposition is wrong whichever way we turn ourselves from a realistic perspective. And then even if it is the law of arbitration that does apply, it might be then the starting point to assess which parties can be joined that are non-signatories if the theories are such that they typically are dealt with within sort of the normal exercise where you define the scope of the arbitration agreement, where it's sort of, it could be agency, for instance, or it could be succession. That could be natural to look at the law of the seat of arbitration. But when it's based on these, as I mentioned earlier, these non-contractual theories of consent that are leaning more towards equity, then most domestic law systems, at least in civil law countries, doesn't have those principles, although they are generally accepted in international arbitration law. So just residing only with the law of the place of arbitration in these cases will lead to unsatisfactory results, and results that were not foreseeable to the parties who thought that they were buying into international arbitration, not just domestic law.
Let's
Juan,
be
you
honest
can
here,
begin?
Marcus. Oh, sorry,
Go ahead,
Patricia.
Shirley. Go ahead.
Just let's be honest here. I would say, given the development of international arbitration worldwide, I have yet to see, and I may be proven wrong here, a jurisdiction that doesn't have a separate set of rules or framework specifically for international arbitration, which takes into consideration all of the factors that you just raised.
I can tell you more than 10.
And
You've been lucky.
one of
list
them might be the Arbitration Act 1996 for England and Wales.
But
Oh,
even
your
if it
eyes
was
are
the
going
seat
to
of-
the ceiling, Sherlin.
Even if it was the seat of arbitration in the UK, I cannot imagine that there are certain factors that Marcus had just raised that wouldn't be taken into consideration as the law of the seat for the purpose of joinder or for other procedural aspects.
Okay, so you just conceded you're not very imaginative. Patricia, we need some help here.
I think Juan is going to give us some help. I keep waiting for him to share with us. He's thinking deeply, I see.
I think he was thinking whether or not I was born yet in 1996, but I was. It's okay.
So I think we're deviating from the main discussion. Going back to what Marcus said, I do want to make one point of note. I see that there's a lot of discussion going on about the parties' expectations when they sign an arbitration agreement and what law they expect to apply to the validity of the arbitration agreement and to consent. And my biggest problem with this is that the contrary proposition basically gives us no answer to deal with this expectation. So if we go through their analysis where there are multiple laws that may apply, what expectation can we really achieve here? What do the parties really expect? At the end of the day, the law of the seat gives us a very clear roadmap. And the law of the seat, in this case, completely fulfills the parties' expectations because they know what the applicable law will be. And at the end of the day, like I said, it's not just about the institution deciding. There are international rules derived from international conventions that tell us that the law of the seat should be, or at least presumptively it is, again, the law of the arbitration agreement.
I don't think the parties will expect, or the legitimate expectation is related to finding a one-size-fits-all solution, because this is not practical. Arbitration is about consent. And when they consent to arbitration, they consent and they are aware that their dispute may or may not include a joinder, that may or may not be based on domestic law, or may not be related to the merits of the case itself, in order for the tribunal to examine this side of the jurisdiction with the merits of the case. And in this scenario, the arbitration, the law applicable to the arbitration, to the merits of the dispute, will play a major role in deciding on the issue of the joinder. They are aware of all of that, but just to put it that one size fits all is the solution, I really don't think this is actually the right solution in arbitration. It's a case by case.
Let me introduce the question from David Biggie, and I'm reading this. Seems to me that we're focused solely on law as between the two direct parties to the arbitration. I'm a bit concerned that we are ignoring law that might be applicable to the third party or the third party's contract with one of the arbitrating parties. Shouldn't the analysis include some consideration of the law under which the third party's rights and obligations might be determined? Marcus?
Yeah, I was about to follow up on Juan's argumentation, just connecting to that Juan is arguing that the parties would expect or have a sort of greater visibility or foreseeability if it's the law, the place of arbitration that applies. But non-signatories doesn't necessarily involve themselves in the choice of the seat of arbitration. So the foreseeability for them is zero. In some situations, they may have been involved in the negotiations of the arbitration agreement, but I would argue that in most cases they aren't. So the foreseeability argument is null and void in my eyes. And that's a further argument why we shouldn't sort of lock in just on the law of the place of arbitration.
Any other comments to David's question?
Yeah, so that is a very good question. And I think it goes precisely to our point. Having to consider a third country, another random country that was not part of the formula, adds a massive issue of uncertainty and lack of clarity. And it is not very clear to me how an arbitrator would apply principles of another country where there is simply no connection to the arbitration. That the logic for the arbitrator, the place where the arbitrator will derive its powers from, has to be the law of the seat. That's the law that should apply for purposes of the procedural decisions and for purposes of the validity of the agreement. So it makes sense that it's the law of the seat that is the one to resolve these issues.
Well, in the Q&A, we have a comment from Stephen Skolnick that he says, why isn't it a two-step process? One, look to the authority to join under the law of the seat. And two, if so, what law should apply to the agency, alter ego, estoppel analysis, et cetera, to the issue at hand?
Well, isn't that the U.S. Supreme Court position? And hasn't Gretta already said she's smarter than the U.S. Supreme Court?
Look, what I heard is you said that, Mark. But I don't think what Steve's proposing is contrary to what we're suggesting. We're saying look to the law of the seat first, and that's going to lead you to different outcomes depending on what that law is. But that's where you should look, and that's exactly what we're saying. So Steve, I totally agree. Welcome to Team Pink.
I understood your position to be look at the law of seat only, not look at the law of the seat first. So I don't think that's a fair characterization. I mean, I think that Steve's position actually only further supports our point, which is you cannot look at the law of the seat only.
Well, I'm going to now offer each of you 2 minutes to do a closing argument, and then we'll take a new poll before we move to the next debate. So we'll see if you changed any minds. So may I invite to the closing statement of the proponents.
Thanks, Patricia. I think what we've heard through this is that you have before you one proponent that is clear, efficient, straightforward, makes sense, and another proponent that is basically all over the place, and you're not going to know what you're going to get. What we're suggesting is looking at the law of the seat to resolve this issue. Why is that? We all agree, I think, at this point, this is an issue of consent. The only consent that we're seeing is the arbitration agreement, and either as an express choice of a law of the seat or a mechanism to choose the law of the seat. This is the only thing that we can all agree there is consent on. And that's, as we also all agree, is the cornerstone of this issue. It's really a simple issue at the end of the day. It's the law of the seat that makes sense. All the kind of hodgepodge, haphazard ideas that have been discussed as an alternative just simply aren't practical or reflective of that real focus on consent, which we all agree is key.
And we invite the Teal team to make their closing statement.
I think the other side is proposing efficiency at the sacrifice of party consent. We're not all over the place. What we're trying to honor is what the parties have agreed to. And we've already put forward a few situations in which the law of this, just looking at the law of the seat only, would probably violate party consent, and the parties wouldn't be very happy with that outcome. So that's why looking at the law of the seat only is not the appropriate situation. For example, as Marcus raised, when there's already in the arbitration agreement a governing law to analyze the arbitration agreement, when the law of the seat is not specified, that's another situation. And as was raised by Steve, we may need to look at the law applicable to the third party that's being joined. So there's a lot. It sounds more like the argument is doing law is hard, so let's make it easier. But that's not what we're here to do. We're here to get to party consent and do what the parties wanted. So that's why looking at the law of the seat only is not appropriate.
So with that, let's go to the poll. Can we get the polling to see, Rafa, if anyone has changed their opinion? And now we really expect all of you to join in the poll.
I'll relaunch the poll right now, and we'll see what the results are.
Okay, we're coming in. We're coming in. Come on, everybody has to have an opinion. Lawyers get paid to have opinions. Well, you guys are running neck and neck. We need a little more voting going on, neck and neck. Oh, wow, we have to go on for another 10 or 20 seconds so we don't have a tie here. Come on, you tiebreakers, come in, come in. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. With 1 point difference, the proposition lost. So I guess Rafa's showing the results now.
I think you already, or Mark already clicked share. So I think the attendees should be seeing the results.
Great. So, well, congratulations, Teal team. Let's move to the second debate and see if you're going to continue on a winning streak or if the pink team is going to overtake you on the next debate topic. And I will invite Mark to introduce the next topic.
And thank you for that kind offer, Patricia. I do want to begin, though, with 2 remarks. First, I want to remind all of the attendees, you can put your questions into Q&A or you can put them into chat. And if we like them, we may even use them. If we don't like them, we'll treat them just like we're treating the advocates. Second, with respect to the next debate, I want to quote Kristina. Doing law is hard. Let's make it easier. So let's see what happens with this. The debate question is, arbitration is perfectly suitable to resolve IP disputes. Now, what team is going to take the pro side of that and begin with their opening remarks?
They'll be us.
Go.
So I'll give the opening statement for the Teal team. So arbitration is the best forum for IP disputes because it's a cheaper alternative, it has better decision makers, and you can achieve better results. It's a cheaper alternative because you have less discovery than, especially in the US, for example, that can eat up a whole lot of your money and time. It's faster, which also makes it cheaper. The AAA did a study that it takes about over 2 years to get to trial in the US, for example, and less than a year to get to a hearing in a AAA arbitration. So you're getting a lot of savings just from and there's also just from that. And there's also a limited appeal, which again makes the final decision come a lot faster, which also saves you some money. You get better decision makers because you get to choose who your decision makers are. You're not stuck to a jury. You're not stuck to a judge who might not know anything about IP. You get to decide who is deciding your dispute, and they can have, the specialized expertise that you need, which is particularly important in IP litigation, which might be very complicated and include a lot of science that's difficult for non-IP lawyers. And you get better results. First, you get one forum instead of having to engage in multi-district litigation. The decision is inter partes instead of applying, completely invalidating the patent, which actually both sides usually want, right? Because the side, that one doesn't care about the other parties, the side that lost might want to mitigate the bad result. It's easier to enforce because of the New York Convention, and the proceeding is confidential unless, you decide that you want to make it public. So that is also better for the parties. And for all those reasons, IP is the best forum for, arbitration is the best forum for IP disputes.
All right, Team Peak, that's a pretty significant barrier to overcome. Who will speak?
Thank you for that very wonderful introduction into my intro as to why Team Pink is going to win this issue. So let's just kind of start off. Since we've been talking about the United States Supreme Court, in a little bit of homage to the late RBG, Team Pink would also like to be known as Team SJG, just to complicate matters a little bit. But here I am, Sherlin Tung, to establish why arbitration is not perfectly suitable to resolve IP disputes. Now, my learned colleague raised that arbitration is in fact better to resolve these disputes because it's a cheaper alternative. They have better decision makers and they give better results. I also find it interesting that it was Team Teal who initially argued for the other issue, that one size doesn't fit all, but yet here they are trying to say one size does fit all, right? Arbitration is just better for IP disputes. Now, as we know, as we've been saying since the first issue, arbitration is a private dispute resolution method, basically based on consent between the parties. So the parties have agreed to submit their disputes to arbitration rather than litigation or another form of ADR. Now, it's within this agreement between the parties that basically sets out the rights and obligations, and that includes matters that are subject to arbitration. Now, even though these parties' contract determines the issues that are subject to arbitration, it's also important to remember that the jurisdictional law where the arbitration will be held, as well as the jurisdiction where the final award may be enforced, sets out certain issues that cannot be arbitrated. And in this respect, there are certain IP disputes that just cannot be resolved through arbitration. For the following reasons, Team Pink basically argues why arbitration is not suitable to resolve IP disputes. First, arbitrating IP disputes will only have a limited effect. Basically, the award that comes out of an arbitration is only effective or binding on the parties that are related or parties that are a part of the arbitration proceeding, rather than other parties which may be impacted by this dispute. The second reason, arbitration may result in potential inconsistent decisions over this same IP right that has been resolved in an arbitration proceeding. Third, there are certain types of IP disputes that are deemed non-arbitrable in certain jurisdictions, which will result in enforcement issues in those jurisdictions. And fourth, even if such disputes could be arbitrated, parties can and will face challenges in obtaining interim measures or other supporting court proceedings in aid of arbitrations. Now, let's go first to whether or not an arbitral award is binding on third parties and why it's important. As we all know, IP rights are actually quite complicated. It's not so simple that there is only 2 or 3 parties that perhaps have entered into a contract that'll be affected. Oftentimes, IP rights will involve third parties. They're also determined by relevant jurisdictions and also court authorities or regulatory agencies that aren't going to be bound by these arbitral awards. And as a consequence, even if an arbitral award were to be issued in relation to these disputes, that doesn't necessarily end the problem there. There could be future third-party disputes that are going to be filed against parties that already thought that they resolved their dispute in arbitration. Also, with respect to why it's important to have an arbitration over issues that can be arbitrated. There are a lot of jurisdictions in this world still, even though arbitration has become more popular, but certain jurisdictions still don't allow for arbitration of IP disputes. For example, in the EU, Article 24.4 of the EC Regulation 1215/2012 provides that disputes directly concerning the validity or existence of registered IP rights are non-arbitrable, instead being subject to the exclusive jurisdiction of specified national courts. Now, if we have arbitrations of IP disputes involving such member states, that award ultimately will likely not be enforced. And as my learned colleague brought up, it actually won't be cheaper, right? You go through an entire arbitration proceeding, and what you result in more costs having to fight a challenge to the award or setting aside. Now, I am going to actually conclude and proceed on to the debate, as I think I'm running out of time, but
yes, you're over time. You're over time.
Team Pink believes that arbitration is not suitable for IP disputes.
Well, thank you, Sherlin, for matching Yehia in breaking the rules. We're grateful for that because, after all, we're always breaking the rules in the coffee house debate. So I've listened very carefully to what each team has argued, and I'm puzzled. You know, it's been market practice for decades and decades. The drafters of IP license agreements, even if they include an arbitration clause, they exclude from arbitrability things such as IP validity, patent infringement, scope, enforceability. They leave all of that to the courts. So for a team that would argue that arbitration is perfectly suitable to resolve all IP disputes, why are you smarter than the people who practice in this area for a living?
I'm not saying I'm smarter in any way, but I'll anyway try to respond. I think the opposition team is putting arbitration in a much more somber light than it deserves in terms of arbitrability. And I think the habit that you mentioned about drafting arbitration agreements that exclude certain areas of IP from arbitration is an old habit that is not up to date with the evolution of resolving IP disputes through arbitration. In fact, the non-arbitrability of validity of registered IPR is almost an issue of the past. It's only a minority of countries where there is sort of a prohibition against arbitrating validity issues in terms of registered IPRs. I think the majority of jurisdictions allows arbitration of validity of registered IPR as long as it only has this inter partes effect. And then the opposition team tries to make out that as a big major deficiency in arbitration as an alternative to state court litigation, but it really isn't. If you're a patent owner and the validity of your patent is challenged, I think you would prefer that it only has inter partes effect if it is indeed invalidated. And if you're the party seeking invalidation, it's because you want to utilize that invention that is allegedly patented. And if you succeed with that challenge and it's invalidated, you would rather have sort of the sole advantage of knowing that and it only applies to you rather than the competition. So why would you want erga omnes effect in those situations? It's better with arbitration.
So Rafael Carmona has reminded me that I'm an incompetent moderator because I forgot to ask for the poll before we went into the debate itself. So Rafael, I would be grateful if you would put up the poll and all the attendees can vote. And then we will ask Team Peak to respond to what Marcus has just said. Well, looking pretty tight once again. What is it with this audience? It seems to be split almost 50-50 on both of these questions. Come on, attendees, put in your votes. We've got some time left. Keep voting. Don't be shy now. No one knows who you are, so we can't embarrass you, only the oralists. And Rafael can embarrass me. Oh, you like that, did you, Rafael? Everybody notice I have to be nice to Rafael. He's supervising me in a case where I'm an arbitrator.
You give me too much power. You attribute to me too much power indeed, Mark. I don't think anyone can control you.
Oh, take the knife out of my breast. All right, I'm going to count down from 10. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. This time we've got a little more space between the in favor and the against. The in favor, 16 in favor, 57%. The against, 12 voting in that side, 43%. So right now, support for arbitration perfectly suitable to resolve IP disputes has the lead, 16-12. So
okay,
let's
think it's ready to fire up. Juan, are you ready to respond to Rafael or Gretta?
Yeah, let's do this, of course. So I know that the opposing team throws out a lot of very general benefits for arbitration, some of which I actually think are incorrect. So they say that arbitration is cheaper. And while this is the universal proposition that you always hear, even when you're studying arbitration for the first time, I think there are a lot of studies that show that parties really don't mind the whole cost aspect as much. There are many other more important things, like, for example, the quality of the arbitrator that the parties to an arbitration agreement look for.
How about confidential procedures?
And that, you know what, that was actually what I was going for. Opposing side says that arbitration is confidential, and I'm sorry, but that one is just plain wrong. That is not a universal rule. So I don't think that characterizing arbitration as having that benefit is correct. That depends a lot on the specific rules and the law of the seats. So saying that, I don't believe is right. What I want to focus on, though, is that the issue with IP rights is really public policy issues and participation of third parties. In many cases where, for example, there's a patent infringement or a trademark is being used by someone that doesn't have a right for this, you have to ask, how does arbitration help us? You can't get a cease and desist from an arbitration against a party that is not a part to an arbitration agreement. So how does that give us any kind of benefit or protection for the owners of IP rights? I think those are the real questions that we should be looking at.
Well,
I think the opposition has missed many years of development in arbitration in order to make such propositions. Actually, they are saying that arbitration is not fitted to settle IP disputes because first, what about a special judge? Actually, most of the arbitration centers have decided to have special lists of arbitration practitioners with specialty and experience in IP in order to settle this, and I can name many of them. In addition to that, arbitration have witnessed the introduction of emergency.
Excuse me, yeah, but isn't this sound a bit like you're just trying to promote that lawyers, people like yourself, can get more business acting as arbitrators, getting on these lists, representing clients, because you wouldn't be able to represent a client in the Northern District of California in an IP dispute. So isn't this a bit self-serving?
So what's wrong with being self-serving, Patricia?
I was just about to ask the same thing. And I actually also wanted to follow up on a point that Sherlin made in her opening. She said that we are going for one size fits all. And I just think that that's not accurate. Actually, one of the biggest benefits of arbitration is that it's flexible. It's based on party consent. And so you can create whatever procedure you think is best for your dispute. You could, you can require mediation, for example, that might lead to an early resolution of the dispute. People like ICDR.
Christine, are you saying you can't ask for mediation if you're in a court?
Sure, you can, sure you can, but I'm just saying there's a lot of flexibility. That's just one of many examples. There's a lot of flexibility. You can have a very multi-tiered dispute resolution mechanism. And that's not something that you really get in litigation. So you get to decide how you want to resolve your dispute. And I think
what about those companies who actually find it rather important to have access to robust discovery when they're having these types of disputes?
But you can do that too. And you can do that in two ways. You can do that in your arbitration agreement, and you can do that in who you choose to decide your arbitration. Everyone knows that if you choose someone from a more discovery-friendly jurisdiction, such as in the US, you're going to get more discovery. So you can also do, if that's your concern, you get to do that too. You get to tell.
Gretta, is that true? If you get appointed as an arbitrator, you're going to let lots of discovery just because you're based in New York?
No, of course not. Of course not. I mean, parties choose international arbitration instead of going to courts for a reason. And one of those is different types of discovery that are allowed in one versus the other. So I think that's, I mean, you want to go on and on about party consent. I mean, let's give some credit to it then. If you're consenting to arbitration, you're not consenting to US style discovery. But I actually wanted to respond to something else that Kristina is talking about so much with flexibility. And I think this is really the crux of what the blue team is missing on this issue. Yes, there is flexibility in arbitration generally, but the problem we have with IP, why it's not perfectly suited for arbitration, is because it's an area where jurisdictions around the world are limiting that flexibility. Marcus has claimed that the idea that you can't arbitrate or validity issues is a thing of the past. It's simply not true. Sherlin raised the EU regulation. That's not a thing of the past. And there's other jurisdictions like China where, major jurisdictions where this is not a thing of the past. So you want to go on and on about flexibility, but I mean, that's the crux of the problem, is that when it comes to IP issues, there is not the same flexibility that you might have in other, a general contract dispute.
Well, I think, wait a minute, Kristina. I think you're all ignoring the question that I put to you at the beginning. Think about what the practitioners in this area are actually doing. And they're carving out IP validity, patent infringement, scope, enforceability from arbitration clauses. Now, if they do that, we know in most, for example, license disputes, the licensor brings a claim for breach of contract and non-payment of royalties, to which the licensee almost invariably responds by saying the IP is not valid, there's infringement, it's outside the scope, or the IP is not enforceable. The effect of which is to immediately destroy the arbitration. You either have duplicate proceedings because you have to go into court to deal with the defense or the counterclaim as a result of the defense raised and the exclusion in the arbitration clause, or you just have to give up and go to the only jurisdiction that can do all of it, and that's the courts. So isn't the real answer that you have to respect what the parties are actually doing here, not this theoretical stuff I hear from a bunch of arbitration lawyers? Come on, someone help me out here.
Yeah, Mark, I mean, as always, you're totally right on this point. The parties, and
Yeah. The check's in the mail, Greta.
Good. But that's an important part to consider here. The parties don't want this either. And the reason is because IP rights are something different, and they're dealing with different legal regimes and different laws. That means different laws, not just to validity, interpretation issues, but it comes to damages issues, enforceability issues, all kinds of things. And that's, I mean, as you rightly point out, the parties don't want that.
Greta, I know that New York has been in lockdown, but haven't you been noticing recently that there's been a huge surge of interest from companies, particularly tech companies, to begin to arbitrate and, as Ray points out in the Q&A, and mediate disputes? You're in lockdown. You're not noticing what's happening.
Look, we're not.
I think the bottom line is, especially in the US, IP litigation is getting super expensive. So people don't want a 5-year, $9 million battle over their IP rights. People
but Kristina,
mediate their disputes. People are choosing arbitration. And I don't think that it's accurate to say that just because you raise a question of patent validity that you can't do arbitration. A lot of jurisdictions allow for inter-parties decisions of those issues. So when you raise that defense, you can stay in arbitration.
not if the contract clause provides that. The contract clause is what I'm focusing you on, Kristina. And the contract clause declares those subjects to be non-arbitrable.
But if the parties can agree, then because arbitration is based on party consent, the parties can agree to stay in arbitration if that's what they want to do, despite the fact that those defenses being raised. And then that
Juan is
I don't think it's necessarily fatal.
Juan actually raised his hand. We're going to give Juan the mic.
So thank you. So I think the existence of these carve-outs by themselves show that the proposition is incorrect, because the proposition is that arbitration is perfectly suited for IP disputes, and that is not the case. If that were the case, carve-outs would not be necessary. Why should we have to eliminate certain parts of a potential dispute, potential defenses, potential arguments in order to go to arbitration? And like Mark said, at the end of the day, what you're risking here is a parallel proceedings, risk of parallel proceedings, and that is definitely not something that you would call efficient.
Could I respond to that?
Yeah.
Yes. Okay. Picking up on what Juan just said, I think relying on the argument inconsistent results is flawed. I mean, IPR in today's world is cross-border in nature. IP disputes are more often than not multi-jurisdictional. And what is the alternative to arbitration? It's state court litigation. You would have state court litigation in several jurisdictions at the same time. That is a concrete risk of inconsistent results. Sure, there is a small risk of inconsistent results with arbitration, but that is only if one of the parties takes recourse to courts. It's the court's fault. It's not the fault of arbitration as such. And I think Juan also earlier made references to quality of arbitrators, that you're dependent on that, and that confidentiality isn't all that we made it out to be. But again, what is arbitration to be compared with? State court litigation. At least in the jurisdiction I come from, courts are quite public in terms of IP disputes. The confidentiality they offer is none, whereas in arbitration you do have the possibility to agree on the level of confidentiality that you like. Also, you have a say in who you choose to decide on your case. In most jurisdictions, you have no say over who the judges will be in an IP dispute before a state court. So again,
maybe the solution is that in many courts today, they have now developed specialized IP panels within the national courts to handle these cases. And we also have the rise of the international commercial courts. So maybe there's a new kid on the block.
But I think what we need to actually address first, let's go back to these inconsistent decisions. That's actually a bigger challenge or a more likely result from arbitration rather than court litigations, because the whole purpose is an arbitration only binds the parties that are actually bound to that arbitration proceeding or the contract. And as we've seen, IP rights or IP disputes oftentimes will impact third parties that are not even relevant to the contract and dispute. I mean, look at the VIS problem today. Now, if we go also to Marcus's point of you get to choose your arbitrator in arbitration, yeah, we like to say that that is one of the fundamental rights of a party, but let's be honest, it requires the parties' consent. The parties have to agree. Otherwise, if you have a 3-member tribunal, one party can choose one, another party can choose another, but then the third arbitrator is not going to be the decision of the parties. And just overall, when it comes to costs and efficiency, it's not going to be the final solution for resolving an IP dispute, because if that dispute ultimately is one that's non-arbitrable or cannot be enforced, where you're trying to enforce the award, again, your costs soar, they double, they triple, and it becomes unrealistic when it comes to efficiency on time and money.
So, Teal Team, what I think Sherlin is saying is that judges are free, but you get what you pay for. And at least in arbitrators, you kind of know what you're paying for. How do you respond to that argument?
I think this is not completely true, because as Kristina said, in some jurisdictions, resorting to the judge may result in more significant costs than arbitration. And there is one very important point to add here: the allocation of costs in arbitration. Even if in some jurisdictions the rule is the division of the costs between the parties, they can add this to the arbitration clause, and in most of the jurisdictions, the winning side will not bear the costs. So this is an element actually that is in favor of arbitration, not in national courts.
Well, I think you would get a lot of people from each side pays their own jurisdictions who would disagree with that. I come from one of those jurisdictions, and a fairly large number of the lawyers and companies in the United States don't think that losing side pays is a good idea. Aren't you just, Yehia, expressing your own cultural preference there?
I'm just saying that there is a tool that can be used in arbitration, depending on the culture, but a tool that doesn't exist in courts. So it's at the end, it's in favor of arbitration being used to resolve the dispute.
And if the only tool you have is a hammer, then every problem looks like a nail. Do the people on the pink team have any answer to this? I'm going to call on you if none of you have the answer. Sherlin, you win the lottery. Do you have an answer?
I'm going to have to rely on my colleagues on that one, because I was trying to put together a closing. I'm looking at the time.
Okay, Gretta or Juan Pablo, which one of you is going to step up here?
I mean, I don't really know how this is helping and advancing their position at all. I mean, sure, the right to apply for a cost submission, it's a general feature of arbitration. I don't understand how that adds anything to saying that arbitration is perfectly suited to deal with, IP disputes. That's just a general point of arbitration. And as Sherlin very correctly pointed out, because you don't bind third parties to these issues, there's a much bigger issue of cost across relitigating, re-arbitrating things with multiple parties in multiple jurisdictions. So sure, I mean, you can have a cost award in any arbitration if it's in the agreement, but how is that specifically helping here?
But you don't.
Team, I wonder, you guys sound like you're making the kind of arguments that could have been made 3 decades ago about arbitrating competition law issues, or that were made 2 decades about securities law issues, or more currently financial issues. It seems like you're just running the same anti-arbitration arguments.
It's not really an anti-arbitration argument if you consider the state of the law in various countries. Arbitrability issues are still a problem in many places, so it's not like we're being anti-arbitration just for the sake of it. It's a reality. IP right disputes are very complex. Issues such as, for example, arbitrability, third-party rights, like I said, preventive measures, all of these are things that we still have to consider as part of the complexity. So if you take all that into consideration and you bundle it up in one big bunch of problems, then you need to conclude that it is not the most appropriate manner. It's not preferentially the best one to resolve these kinds of disputes.
All right, so Kristina, I hear Juan Pablo arguing that arbitrators can't deal with complex problems, but I think you were trying to say something earlier.
I actually just forgot my train of thought, unfortunately.
Oh, you don't even have Sherlin's excuse that you were trying to do the closing statement.
No, I just literally forgot.
She was more honest.
Yeah. Okay, so why don't we then turn to closing arguments? And then
sorry, I just remembered the one thing that I was going to say.
You weren't ready with your closing argument, huh, Kristina?
No, sorry, I'm not doing it, but I just remembered the one thing I was going to say, which is I think that there's an assumption in the pink team's arguments that that companies or parties want these decisions to have larger applicability. And I think that clients don't, I think that's an assumption that's not necessarily fair. And I think a lot of people are turning to arbitration. Arbitration is growing in the IP field because, in part because clients don't want that result. So I just, that was
it's maybe part of the problem that the arbitration community has not been listening to the IP client community, and that we need to adapt arbitration's tools and procedures to better serve those interests. Isn't that possible?
Yes, and I think also, jurisdictions are, so that's why jurisdictions are also slowly changing, right? It used to have less ability to arbitrate patent validity and things like that, and that is growing because also, again, the tidal wave, I think, is going in our direction, which indicates that arbitration is a good forum for IP disputes. And so I think that's where things are, even if they're not perfectly there yet now, I think that's where things are headed because it's a forum for IP disputes.
So you think that the legislators in the US, in France, in Portugal, in Italy, just simply have it wrong when they have statutory restrictions on arbitration of patent disputes, so that a decision between the parties to the arbitration has no force and effect on any other persons. I'm quoting the US statute on that point. You think that they're standing in front of a tidal wave?
Well, the US jurisdiction specifically, I will say, it does allow for inter partes patent validity issues to be arbitrated, is my understanding of current US law.
That's correct, but it does not have any impact on third parties. And that's the rule in France, Italy, and Portugal as well. Those are not small arbitration unfriendly countries. Those are serious participants in the international arbitration community.
Yeah, but I think that that's okay. I don't think that I don't think IP clients want for it to necessarily have an impact on third parties. I think
which is why they carve
arbitration.
Which is why they carve out of arbitrability, validity, infringement, scope, and enforceability. I don't think the practitioners necessarily agree with you, Kristina.
Why are we assuming that as a fact? I don't think everyone is necessarily carving it out. And it's a little bit of a chicken and the egg situation, right? Are they carving it out because of the way the law is? And if the law changed, they wouldn't be carving it out because it is a good forum for arbitration?
Well, that's an intriguing question that now leads us directly to closing statements. So I invite the team that supports the proposition arbitration is perfectly suitable to resolve IP disputes to make their closing argument first.
Thank you, Mark. Well, the proposition that we have advanced is essentially a no-brainer. Arbitration is perfectly suited for resolving IP disputes. It brings a wide array of advantages, some of which were addressed by Kristina in opening. It is a procedure based on adjudication by decision makers that are neutral and that have been handpicked by the parties themselves for their relevant expertise. It's not a lottery like litigation in terms of picking judges. And arbitration comes with procedural flexibility. It comes with unrivaled speed, cost efficiency, and confidentiality. And equally important, I think arbitration offers a single forum for the consolidated resolution of IP disputes that are not restricted to one single jurisdiction. And the number of multi-jurisdictional disputes is ever on the rise. And let us not forget that the output of IP arbitrations are arbitral awards that are readily enforceable across most of the globe. And the same cannot be said for state court judgments. Now, in considering the proposition, one point that we haven't touched upon is that arbitration brings all these upsides that I just mentioned, and almost without exception, the possibility to seek support from state courts for any actions that require the coercive powers that arbitrators lack. So if a party needs interim measures and need them to be enforceable, not just emergency decisions from an arbitrator, but enforceable decisions, they can take recourse to state courts. Conversely, if you resolve IP disputes through state court litigation, that does not entail that you also will enjoy the significant benefits that comes with arbitration. So essentially, IP arbitration comes with a bonus package and IP litigation doesn't. And that's enough, I think. Now, the arbitration hostile members of the opposition team, they have tried to put IP arbitration in a somber light. They've done so in reliance on certain arguments that may appear appealing at a glance, but they don't withstand closer scrutiny. I will only mention the one that we discussed most, that the alleged lack of arbitrability of IP disputes. I argue that it's mostly an issue of the past. In principle, the only remaining area are limitations in terms of arbitrability of IP disputes in respect of registered IPRs. But the non-arbitrability of such disputes is only absolute in a handful of jurisdictions. In most jurisdictions, you can still arbitrate with inter partes effect, which is what most parties are seeking anyway, for reasons I mentioned during the debate, or it's okay to arbitrate those as preliminary matters, as the example Mark mentioned when it's brought up as a defense. Now, non-arbitrability is basically based on old-styled public policy reasoning, which I think will end in the future. And I think the drafters of IP contracts will come around and pick arbitration over litigation because it has all of those advantages clearly over litigation that I just mentioned. So with that said, I thank the audience for the patience, for the time, and I urge you to vote in favor of the proposition. Thank you.
And now we will hear from the opponents to the proposition. Arbitration is perfectly suitable. Sherlin, I believe you claimed you were going to provide the closing statement.
My colleagues off. Yes, I am going to provide a closing, and hopefully it will be convincing enough to convince the audience that Team Pink is indeed the winner of this proposition. I mean, what it really all comes down to, it really does come down to Team Teal's initial argument of whether or not one size fits all, and Team Teal has already said it doesn't. The question that we have before us today is whether arbitration is perfectly suitable to resolve IP disputes, and it isn't. From what we've just heard in the last half hour or so, there have been so many carve-outs or exceptions as to certain things that could be resolved by arbitrations, whereas other things can't be resolved by arbitration because then those are delegated specifically to the courts. But the question is whether or not arbitration is suited to resolve all of these types of IP disputes. Our colleagues have raised that arbitration offers a wider range of benefits, but let's be honest, they said arbitral awards are enforceable worldwide through many more jurisdictions than court judgments actually are. But arbitral awards need to be enforceable in that they don't have one of the reasons from the New York Convention or relevant state statutes that don't allow for the arbitration award to be enforced. For example, for the issue that is non-arbitrable. Again, Marcus raised that this idea of non-arbitrability of IP disputes is something of the past. But it's not. We've already learned that the EU has a specific provision that says that certain types of IP disputes cannot be arbitrated. They are delegated to the specific jurisdictions of relevant courts. Given some other examples, China also has limitations on what types of disputes can be arbitrated, and they've already said China follows, a bifurcated system, as does a number of other jurisdictions, which basically allow for commercial connections to such type of IP disputes to be arbitrated, but validity of patents and registered trademarks would be deemed as administrative matters that are non-arbitrable. Also in Singapore, they have said that they've recently amended it in 2019. The Intellectual Property Dispute Resolution Act amended Singapore's Arbitration Act to specifically allow for arbitration of certain IP disputes, but again, it's only binding on the parties involved. It can't be bound to third parties or the courts or the regulators that deal with such IP rights. All of these benefits that Team Teal has raised don't fit for all types of arbitration disputes or arbitration proceedings for IP disputes. What we have to recognize is the most important thing in an arbitral proceeding is to have an enforceable award. And if we are to argue that arbitration is perfectly suited for all IP disputes, that just isn't the case, because not arbitral awards will be enforceable. Thank you.
Thanks to both teams. We should now take the poll again to see if either team has moved the dial. Raphael, we hand it back to you.
Okay, and now the poll is open again, and you should be able to vote. We'll see how the teams did.
Well, we've got some movement here, at least in the beginning, although it's tightening up now. But at the moment, against has their nose up in front just a little bit. In favor is lagging a bit behind. Let's see what's going on here. Right now, we've got 17 against and 12 in favor. Seems a bit of a substantial move. Do we have any more attendees who have the courage to vote? There are a couple out there who still haven't punched their tickets. Come on, guys. Oh, I see Sherlin is getting a little worried here. Oh, closing it just a little bit. Why don't we give it another 10 seconds? 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. And the polling stands at 17 against, 13 in favor. So the against team has shown some real movement here.
Team Pink, look at the background. That's the way to go.
So the Pinksters seem to have done well. Patricia.
You win some and you lose some, and each team has won some. We can note that the pink team did manage to actually change opinion. I don't remember from the first debate how much change there was in opinion, but that's all what advocacy is about, is to change opinion. And I think we've seen some great advocacy. I know we've seen some great collegiality and a great sense of humor for all of our debaters to put up with Mark and I trying to be purposefully pesky. I'd like to thank all the attendees who spent their Sunday morning, afternoon, or evening with us. We appreciate having you here because you're what makes this possible. And we really look forward to hopefully seeing everyone for real coffee and pastries and the beautiful palace that we usually hold this in Vienna next year. And special thanks to Raphael, ICDR, to all of our sponsors that make this possible. And let's have a really robust coffee house debate next year. Thanks for this year. Thank you, Mark. It's always a pleasure.
Thank you all very much. Hope to see you next year. Take care. Bye.